This is a video made for Iowa employers who pay Iowa unemployment compensation tax. And the information provided is legal information, not legal advice. This is December 5th, 2013. My name is Marlon Moorman. I'm an administrative law judge with Iowa Workforce Development. The law that I'm speaking of went into effect July 1, 2013. The law charges employers even if they win on appeal. The fact scenario is simple. If an employer fails to participate at the fact-finding interview and loses, once they go up on appeal to an administrative law judge and then win, the employer still pays all the benefits from the date that the claimant started collecting to the date that they prevail on appeal. In order to defeat this, the employer must participate. In order to participate, the best and the most effective method is to have a person on the phone with first-hand knowledge. Now, the key to this is to have someone who knows what's going on, knows why the person was fired, or knows why the individual quit. First-hand knowledge. First-hand knowledge does not include your lawyer. It does not include a third-party representative. And it certainly is not your best friend's brother. We need people who have knowledge of what happened and why. And they need to be on the phone and ready to go at the time the unemployment fact-finding interview starts. Now, if you can't have someone on the telephone and you want to participate by means of documentation, there is a method spelled out in the rules. It's complicated and it's very technical. And I'm going to go through this to try to give you a heads up of what needs to be done. In order to participate by documentation, you still need to identify that individual with first-hand knowledge of why the person was let go or why they quit. First-hand knowledge is key, so you identify the name, telephone number of a representative with first-hand knowledge of the information. Again, not your lawyer, not your third-party administrator, certainly not your accountant, unless they were there and saw what happened. And they have to be available for contact at the time of fact-finding. Now, the employer also needs to provide detailed written statements if you want to participate by documentation. The statements must show the circumstances of the discharge or the voluntary quit. You can't just say a blanket statement, oh, I think they quit because they didn't have child care, or something like that. You need to give all the information, where it came from, and who had the information initially and how you got it. Try to be as detailed as possible telling your story. Now also, if you fire somebody, you want to include the rule or policy from your written policy manual. If you have a policy manual, it's absolutely imperative that you include that. If you've given the individual prior warnings, especially warnings that go to the reason for the discharge, you want to include all of the prior warnings. And now for absenteeism cases, you have three things you need to specify. You need to put in detail the date of the last absence, the reason for the last absence, and whether it was properly reported under your policy. Again, the means of reporting, the way that you require your employees to report, whether it be an hour before the start of shift, an hour after, by text message or whatever, you want that rule or policy spelled out. You want a hard copy from your policy manual included. And then after you get the final absence laid out, you want to follow your policy manual back. If you have 6 months that you go looking at absenteeism, use 6 months. If you have a year, use a year. If you have no real set policy on how far back you go to look for excessive absenteeism, go 1 year. That's a good general rule. And for each absence or tardy, and remember, absences and tardies are treated the same under Iowa law. For each one, the same three things. When did it happen? What was the reason for the absence? Was it properly reported pursuant to your policy? And move through each one of those. That gives the detail that a fact finder will need to decide the case as to whether it's excessive and unexcused absenteeism. Now, what doesn't work? Written or oral statements are general conclusions without supporting detailed factual information. It's all about giving the detail so they know what happened, when it happened, how you found out, and show that it's credible. Now, information submitted after the fact-finding interview is not participation. Now, the ultimate goal is to get enough information at fact-finding that even if you lose at fact-finding, you need to give that fact-finder sufficient information that would show that you would have won if claimant had not shown up at fact-finding. And the rule is specific. It says you must submit detailed factual information that, if unrefuted, would be sufficient to allow the employer to win. So that's your burden. That's what you need to do, whether it be by a person on the phone, participating personally, or by documentation. But by all means, follow those rules and documentation. Get the name and phone number of a person who has firsthand knowledge, and then provide those detailed written statements along with a rule or policy and those 3 rules on each specific absence all the way back. I wish you the best of luck.